What if the laws that allow billions of dollars of dark money to drive American politics are based on a clear mistake? One of America's most prominent legal scholars thinks that's exactly what happened, and he's going to give someone $50,000 to help him prove it. I'm Paul Hodes with my co host Matt Robeson. This is Beyond Politics. Our guest, Lawrence Lessig, is the Roy L. Furman Professor of Law and Leadership at Harvard Law School and the founder of Equal Citizens, an advocacy group whose mission is to fix democracy by establishing truly equal citizenship. On Labor Day, September 4th, 2023, Equal Citizens will launch a video competition with at least one $50,000 prize for whoever can clearly and concisely explain the legal argument for why SuperPACs can be regulated. And Professor Lessig is here to tell us all about it. Welcome to Beyond Politics.
It's great to be here. Thanks for having me.
So help us review the basics here in terms of what exactly are super PACs and how do they come into being?
Yeah, so most people who think anything about this issue know about a Supreme Court case decided in 2010, January of 2010, Citizens United. And what Citizens United said was, if a corporation, like an individual or a labor union, spends its money independently of a political campaign, there could be no justification for restricting that speech, because if it's independent, there couldn't be anything called quid pro quo corruption, this for that corruption associated with it. Now, that decision terrified many people. Many of us thought corporations were going to spend billions of dollars to buy politics. But it's actually a decision not by the Supreme Court, but by the DC Circuit, a lower federal court, 3 months after that created all the problem. That decision, it's called Speech Now versus FEC, decided in March 2010, held that if you can spend unlimited amounts of money, because there could be no quid pro quo corruption, you should be able to give unlimited amounts of money to a political action committee that will then spend that money independently of the political candidate. Because there too, the court said, as a matter of logic, as they said, quote, as a matter of law, which means there could be no facts to the contrary. The court said, as a matter of law, there could be no quid pro quo corruption, so there could be no reason to limit those contributions. That decision created the super PAC. And super PACs, beginning in 2010, have now grown to be the most important money in any major political campaign, from presidents to members of Congress to state legislatures to Supreme Court justices to local school boards. All of these now are dominated by these huge contributors. We believe we can show the logical mistake, simple, obvious, logical mistake that the DC Circuit made, which should lead courts to realize that, in fact, the First Amendment does not protect super PACs, and that states and Congress should have the constitutional power to limit those contributions to avoid the obvious quid pro quo corruption they create the risk of producing.
Before we have you lay out what that logical error was, could you just help us understand the scale of the problem? I could almost see, not our listeners and viewers who are well-versed, and obviously they've had people like Senator Sheldon Whitehouse on the show talking about the ills of dark money in our system. But from your standpoint as an advocate, how severe is this problem? How much is it warping American politics?
I think it is the most important problem. Henry David Thoreau used to say, for every 1,000 hacking at the branches of evil, there's one striking at the root. This is the root. And it's the root because what every politician knows is that they can't take on any issue that's likely to trigger the response of these massive super PACs. And what makes them important, what makes them dangerous, in my view, is not necessarily the amount of money. I'm not sure how much money we should spend in politics. What makes them dangerous is the incredibly small number of people who actually control what those super PACs do. What's important here is the concentration in donors to a very small, the New York Times estimated something like 140 families were controlling American politics because of the size of these super PACs. And that concentration means if you don't like, if you take on an issue these super PACs don't, you have no chance to survive in American politics. Here's a very clear example. We're experiencing an incredible range of climate crises right now. Arizona has had 30 days straight of 110-degree weather. We've suffered Mars-like conditions because of wildfires in Canada. There's the greatest fear that 20 years ago they thought wouldn't happen until 2100, but now might happen as soon as 2025, that the Gulf Stream inverts. All of this because we've not done anything effective about climate change. Why? People might not remember, but until 2010, both the Republicans and the Democrats believed in climate change and believed they had a solution to fixing the problem of climate change. In 2008, John McCain thought he had a better plan than Barack Obama, and maybe he did. But the point is, there was no problem, there was no shame in acknowledging the problem of climate change. Then in 2010, the Koch brothers began to make it known that any Republican who even acknowledged the truth of climate change would find themselves primaried, meaning they would find themselves challenged in their primary. And almost overnight, the Republican Party went from a party that had a different set of ideas for solving the problem of climate change to a party that couldn't even acknowledge the truth of climate change. And that was because literally a handful of people decided that they would spend their billions of dollars to make sure that this issue was not a viable issue for Republicans, which means not a viable issue in the United States Congress, given how close the division is with the role of the filibuster in Congress. So the point is, this is not a democracy. This is a banana republic democracy when a tiny few have this ability to veto what the majority would want, and they can do that because of these super PACs.
So what is the mistake that was made in assuming that super PACs are required by the First Amendment? What's the legal argument that overcomes that mistake?
Okay, so first you have to understand what the DC Circuit thought it was deciding. If you imagine a political action committee that's raising money to spend independently of a campaign, they say, we're going to raise money and we're going to elect Democrats to the Senate, or we're going to raise money and we're going to elect Republicans to the Senate. What the DC Circuit imagined was, okay, imagine a rich guy goes up to that super PAC and says, I'll give you $100 million if you will support Southern Democrats, or if you will support Southern Republicans, or if you support Republicans who don't support climate change, whatever. And what the DC Circuit thought is, if that donor makes a deal with the super PAC, that's not the kind of corruption that Congress has the power to regulate. The only corruption Congress has the power to regulate is a deal that's related to a politician. So if a politician makes the deal, then of course it's corruption. Congress can regulate it. But if it's independent of the politician, then there's no corruption. And that's what the DC Circuit imagined it was talking about. Okay, but skip ahead to 2018. There's a prosecution of a Democratic senator in New Jersey, Robert Menendez. The charge against Robert Menendez wasn't proven. The jury rejected the facts, but here was the charge. The charge was a rich person from Florida said to Robert Menendez, I will give money to your super PAC if you will agree to do the following favors that I want done for my friends in Florida. And the allegation was Menendez agreed. So the point is, there was a deal with a politician to fund a super PAC that obviously involves quid pro quo corruption. And so because it involves quid pro quo corruption, it's exactly the same kind of problem that exists whenever you're talking about large contributions to an individual. The reason why we can limit contributions to individual candidates is the fear that there'll be a deal in there somewhere. If I can give you $1 million in your campaign, people rightfully worry, maybe I'm doing that because you've made a deal with me. That's what exactly happened or alleged to have occurred in the Robert Menendez case. And this, the DC Circuit didn't even consider. This possibility they didn't consider, which is why they said as a matter of law, which means there's no possibility that corruption could exist, there is no corruption in this case. But once you see this is not only possible, but when we're talking about contributions of millions of dollars, seems pretty likely, then you see there clearly is a legitimate reason why Congress or the state should have the power to limit those contributions, just like they have the power to limit contributions to individual campaigns from large donors.
So let me just follow up for a quick second. As a member of Congress, I had my own experiences with people giving me a wink and a nod about political contributions. I had some wonderful times with that. And we were always talking about the influence of PACs, and the wink and the nod really is what goes on in Congress about the independence of the PACs. And it sounds like the DC Circuit simply assumed that because PACs are supposed to be independent, but in practice, frankly, are, in my experience, often much less than independent. Not exactly coordinated, but there are winks and nods and a code that can be spoken between campaigns and PACs. But the DC Circuit apparently ignored the reality of that and just said these giant super PACs can give money to the PACs. The super PAC is thus removed from the candidate. The PAC is, of course, removed from the candidate. So it's all okay. But they ignored the reality.
I think you're right. They ignored the reality. What they would say in response to Congressman Holt is, look, we're not talking about cases where you can show that there was some kind of coordination. In those kind of cases, yes, of course, you can regulate the contribution. And indeed, in states like Maine, if there is coordination, then the contribution is considered to be a contribution to the candidate, which has to be limited under the ordinary law. But what the DC Circuit said was, look, what we are saying is if there is independence in the spending, by logical necessity, there has to be independence in the contribution. And that's the logical claim, which undergirds the whole of this super PAC jurisprudence, that is just obviously false. Because again, in the Menendez case, there you had the super PAC, which was acting independently of Robert Menendez. Nobody was saying that Menendez was directing the super PAC. So the super PAC was certainly independent, but clearly the contribution to the super PAC was not independent. And so if the contribution was not independent, if the contribution was dependent, that raises exactly the concern about corruption that has traditionally justified laws which restrict the size of a contribution. Think again about the normal case. When you were running for Congress, if I came up to you and I said, I'm going to give you $1,000 for your campaign, that's permitted under the existing law. If I said to you, I give you $10 million for your campaign, that's not permitted under existing law. Why? Not because every time somebody tries to give you $10 million, they say, only if you agree to do X, Y, and Z for me. But because a reasonable person could look at that and think, yeah, if they're giving him $10 million, there's probably some kind of deal going on back there. So I'm losing confidence in our political system when I believe that these politicians are being bought by these large contributions. That's why the Supreme Court said you can limit those contributions. Now, the people who are attacking those limits in the first case that considered this, Buckley versus Vallejo in 1976, the people attacking those limits said, you're attacking bribery. You're saying bribery is illegal. And yes, of course, bribery is illegal. So just ban bribery and you don't have to worry about limiting contributions. But what the court said is, yeah, of course, bribery is illegal, but that's hard to police. So what we're going to say is it's okay to limit contributions in addition to banning bribery, to raise confidence that people have in the political system where there is a risk of quid pro quo corruption. And all we're saying is, obviously, the same risk exists with super PACs. And if it exists with super PACs, just like with direct contributions, then states and Congress should be free to limit those contributions to make sure that the public doesn't have the kind of cynicism we all know that the public has when they look at the way politics works right now.
What I find most compelling about your argument is to hone in on the idea of limits on contributions. Because as you say, it's so hard to police the concept of an appearance of an exchange of favors here. The reality is, we all know what time it is, those of us who have been a member of Congress, like Paul, or who have staffed members of Congress and raised money for members of Congress, like me. I know full well when I advise Paul as a member of Congress, I say, hey, boss, there is a vote coming up, and this is what the labor unions want you to do. And we have a fundraiser who sits down the street. And he will tell us, I've had these conversations more times than I can count. He will tell us, look, man, you'd better vote this way. And then I can make my phone calls and I will get all those $5,000, which is the limit of a regular PAC contribution from all these labor unions. I have a list of 100 labor unions here. They will give to you or they will not. And so that kind of exchange of this is what these groups are in favor of, and you need to act a certain way, that is impossible to police.
Right.
The only thing that you can regulate is a limit on the size of contributions. That makes a ton of sense to me. Here's the challenge that I'm going to pose to you. This Supreme Court has ruled in conceptually similar matters in the last 10 years. For example, they overturned the conviction of Virginia Governor Bob O'Donnell, who was receiving gifts and benefits. There is an appearance of a quid pro quo. There was just never this moment where he said, I would like to have an exchange of favors with you. Let's do that, and I will take this money from you. You have Clarence freaking Thomas, who is embroiled in the same arrangement with Harlan Crow, not to mention other members of the Supreme Court. Is there a way around that barrier? That seems like a substantial barrier, or is the focusing on the limit on contributions the way that you get around that?
This argument relies exclusively on the position advanced by Chief Justice Roberts, one of the most conservative justices on the Supreme Court, about campaign finance. Because what Roberts has said, and I want to talk about the campaign finance cases, not the bribery cases, which I think are crazy for all sorts of independent reasons, but
I'm with you.
Finance cases, where the court has struck down limits. The court has again and again said, look, you can only impose these limits where there's some risk of quid pro quo corruption. And if there's no risk of quid pro quo corruption, you can't impose the limits. And so what we're saying is, great, let's embrace that way of thinking, not because you think it's right from ground zero, not because you think it's realistic about the way Washington works, but because you're like, this is the Chief Justice of the Supreme Court. This is one of the most important votes you could be fighting for in trying to establish the power of states and Congress to establish these limits. So let's say, let's embrace your words exactly, and let's embrace your logic exactly. Here is how your logic applies to super PACs. It's plainly obvious that contributions to independent political action committees can raise the same risk of corruption that contributions to candidates can. It's the same dynamic. And even if you don't think it happens 100% of the time, or 50% of the time, or even 10% of the time, what the court has said is where there is that risk, you can establish limits on contributions for exactly the reason you say, Matt, because that's the only thing that we can effectively police. If you're a member of Congress, I mean, there were members of Congress like this, the stupid members of Congress who would say, Cunningham, you knew Cunningham, right?
Yes. Oh, gosh. Yes, go on. Yes. Duke. There it
right.
is.
Cunningham. The guy wrote down on a piece of paper the size of the bribe and what he would get in exchange, what they would get in exchange for it. Okay, those guys are idiots. That's not how Congress works. I'm even okay with the idea of raising money on the basis of what you support, as long as those contributions are relatively small. I favor democracy vouchers, which is like giving everybody a voucher that they could use to help fund campaigns. So if you said to me, look, this is what you need to do to get the support of the members of the union so that they give you their voucher, I'm all in favor of that. That's what democracy is. Build support for the ideas in the political process. What I'm against, what I think our Constitution does not require, is the idea that 5 or 6 people get to sit around a dinner table and decide how billions of dollars will be spent in the political process, and the rest of Washington like bending over backwards to make sure they never upset those billions of dollars, because they know if they do, they're just never going to get elected. That's the corruption, the dependence on this tiny few to fund these elections. And limiting contributions is one way to make sure it's not a tiny few. It's a few more, but it's not 5. It might be 5,000 or 500,000. And that's better than the system we have right now.
All right. So now I've got to press you on something while we're speaking of money. You're a Harvard professor, man. You're also a legal scholar. So usually you make these arguments in classrooms or in courtrooms. What you're doing here with this initiative is a very unusual approach. You are crowdsourcing a prize for anyone who's listening to this, anyone who's watching this. Why are you doing things this way?
So it's extraordinary frustration with my lawyer colleagues, with the legal establishment itself. Basically, the conventional wisdom among lawyers, if you polled 100 lawyers who know what the word super PAC means, and that's not all lawyers, but let's imagine we get the 100 lawyers who knows what super PAC means, and you said to them, does the First Amendment protect super PACs? I think 90 of them would say, obviously, yes. A bunch of them would say, because the Supreme Court has said so, flat out false. But those who know the Supreme Court hasn't said so, but at least have seen what the Supreme Court has said would say the decisions of the Supreme Court make that perfectly clear. I was in part of litigation in Massachusetts where we tried to get the Massachusetts Supreme Judicial Court as well as the Attorney General to recognize the mistake here. And we filed hundreds and hundreds of pages of briefing, literally hundreds of pages of briefing. And the reality is people don't read. They don't pay attention. They don't think about it. Like they think they know what the answer is, and why waste time thinking about something they already know what the answer is? So what we thought is we got to find a way to break through this conventional wisdom, to give people a chance to step back and say, whoa, I missed something here, because clearly the DC Circuit missed something here. And if we could begin to crack this conventional thinking, then we can recruit many more people around the country to begin to take up this fight again, to establish the ability for us to limit the size of these contributions to super PACs to get us back something closer to a democracy. It's still, until we have public funding, won't be a democracy, but something closer to a democracy. So I responded to my own people's inability to grapple with this. And I thought, a pretty good video, pretty good meme, pretty good way for a bunch of non-boomers to say, hey, boomer, you've missed something here, pretty fundamental, might be a way to break through it. So it's the first step. We've got a series of steps, a series of plans for how we're going to get this issue up to the court and give Chief Justice Roberts the chance to surprise everybody by writing the opinion. I think it'll be 7-2. It could be 9-0, depending on whether the originalists are faithful to their philosophy, but at least 7-2 to say, yeah, of course, you can limit contributions to super PACs, just like you can limit contributions to PACs or to candidates. But it's going to take a bunch of steps to get there, and this we think is the first step.
So Paul, I just realized we're idiots. Do you realize how dumb this is? You are, in addition to being a former prosecutor and member of Congress, you're a rock musician. You've won awards for creative music writing. I have a YouTube channel with 25,000. I make videos every freaking day. And here we are telling all of our subscribers and listeners, top 2% podcast on earth. We're telling everybody about this.
I know.
I want the money.
I know. So
why are we telling people about this?
I'm going to write the song.
Lawrence, you are about to be suppressed.
You're going to make the video.
I canceled the show.
So wait a second. I'm going to assume, first of all, that no super PAC is putting up the $50,000. That's number one. Number two, we've got the mouth of the horse speaking here. So let's give our listeners a leg up, despite Robeson's concerns that we're giving away the ranch. I know that there's going to be an independent jury for this crowdsourced creative competition, but what tips do you have for people like us who want that $50,000?
So what I did was I listened carefully to the argument that Free Speech for People made here, based on Larry Tribe's argument and Al Schiller's argument. And I made an incredibly clumsy 13-minute long video.
Don't run yourself down. It's not bad. Okay. It's not bad.
So I made it's not bad video, but it's 13 minutes long, which in internet time is like an eternity, right? But it goes through step by step, how you get to see what the essence of the logical mistake. And so what the winning video will do, like people can make videos of whatever they want. They can talk about the corruption of Harlan Crow. They can talk about the Supreme Court. They can talk about whatever they want. But the winning video will be one that makes the logical mistake so obvious that even Silberman, the author of the opinion, could look at it and say, oh my God, what was I thinking? It's clear that there's a mistake here. And it's clear that means that super PACs are not protected by the First Amendment. And my dream is that somebody does that in 90 seconds or 2 minutes. So that as you're flipping through your TikTok feed, if you are poisoning yourself with TikTok like that, or anything else, you get it and you get it quick, and then it becomes like conventional wisdom. Everybody says, yeah, obviously that was a mistake. And so what are we going to do to fix it? So it is the video that focuses the most concisely and powerfully and effectively on the mistake and shows the mistake that will be the one that actually ultimately wins.
All right. So a public service announcement. Here's what we're going to do, because Paul and I were just these kind of guys. We want the money. I'm not going to make any bones about that. However, we will put this video link in the show notes on both the audio pod and this video. We will put it up on the community page. So all 25,000, we're going to email it out. My Blue Amp channel partner, Cliff Schechter, maintains a 1 million person email list. Guess what? You're all getting this email. We are going to crowdsource this. because that's how much I care about American democracy, despite my own pecuniary interests. Lawrence Lessig, thank you so much for being with us on Beyond Politics.
Thanks for having me.